India Legal presents Courts Roundup.
Hello, I'm Hishay and you're watching Courts Roundup. In this program, we bring you the latest legal news and details of court proceeding. And before we begin, here's the headlines. Supreme Court seeks centre's reply on plea challenging farm laws. Are centre to file reply within 4 weeks. Court also directs the Attorney General to submit the details of related petitions filed in other courts. Hathras victim family appears before Lucknow bench of Allahabad High Court, accuses Hathras administration and police of not conducting fair probe, says victim was cremated late at night without our permission. Supreme Court allows a NEET exam test on October 14 for students who could not appear due to COVID-19 or being in containment zones. Petition also filed in court seeking extra attempt for civil service exam on account of COVID. This is a good petition, says CJI Bobde while issuing notice on plea seeking equal protection for transgenders against sexual crimes.
India Legal presents Courts Roundup.
The Supreme Court on Monday issued notice to the central government on 3 writ petitions challenging the 3 farm laws passed by the parliament recently, which have attracted opposition from several farmers' groups across the country. The bench headed by Chief Justice of India S.A. Bobde asked the Attorney General to file a reply to the petition within a period of 6 weeks, and the bench was considering 3 writ petitions filed by Manohar Lal Sharma, office bearers of Chhattisgarh Kisan Congress and DMK MP Tiruche Siva. At first, the bench, taking up the petition filed by M.L. Sharma, observed that there was no cause of action for the petition. Where is the cause of action? CJI Bobde told M.L. Sharma, who was appearing as party in person. You go and acquire a cause of action. We don't want to reject your prayer. We will allow you to withdraw and come back when a cause of action arises, CJI told Sharma. While hearing the other 2 petitions, the Supreme Court asked the centre to file a reply within 4 weeks. The court also directed the Attorney General to submit the details of other related petitions filed in other courts in this regard. The Supreme Court on Monday allowed NEET test to be conducted on October 14 for students who missed the exam on September 13 due to the COVID-19 or due to being stuck in containment zones. A bench headed by Chief Justice of India passed this order based on the request made by Solicitor General of India Tushar Mehta. The result will be declared on October 16, the Solicitor General informed the court. Earlier, the Supreme Court had dismissed a bunch of petitions seeking the postponement of NEET exam amid the COVID-19 pandemic. The National Eligibility Cum Entrance Test 2020 exam was held on 13th of September across the nation from 2 p.m. to 5 p.m. The National Testing Agency, the body that conducts the medical entrance exam, said that about 88% of 15.97 lakh candidates who had registered for the exam took the test. As per the standard operating procedure, candidates who were infected with COVID-19 or hailing from containment zones were not allowed to appear. The Supreme Court on Monday directed the petitioner to serve an advance copy on UPSC and DOPT in a plea on behalf of 24 UPSC aspirants seeking an extra attempt in the civil service examination in the year 2021. A bench of Justice A.M. Khanwilkar, B.R. Gavia and Krishna Murari did not issue notice on the said plea, but stated that they will hear the plea next Monday after a copy of petition has been served upon the concerned respondent. The petition states that an extra attempt is pertinent because their preparation has been severely disrupted on account of COVID-19 situation and also because they will become age barred next year. In this context, the petition has sought quashing of the decision dated 9 September 2020 of the Centre, whereby according to the averment representation put forth on behalf of the petitioner seeking grant of a one-time age and attempt relaxation in the Civil Service Examination 2021 have not been properly considered. It is submitted that all petitioners will have crossed the maximum age prescribed for appearing in UPSC exam by the date of UPSC exam 2021 are notified. The plea reads, it is averred that the problem faced by the candidates have been duly recognized by the candidates in respect of their preparation in CSE 2020 in its notice dated July 1st this year, and an option of opting out for student appearing in CSE 2020 was provided to candidates in order to prevent exhaustion of their attempts. However, while doing so, the UPSC failed to consider the position of person like the petitioner who cannot withdraw unless and until they are also provided a one-time age relaxation, the plea further said. And amid tight security, the family of 20-year-old woman allegedly gang raped and tortured in Uttar Pradesh, Hathras, appeared before the Lucknow bench of Allahabad High Court today. The victim's family accused the Hathras administration and police of not conducting fair probe into the incident. Even an FIR was not launched by the police, the family alleged. They also said that the victim was cremated late night by the police without their assent. And the 20-year-old woman from Hathras was allegedly gang raped and assaulted by 4 upper caste men from her village. The state government has come under heavy criticism over the handling of the case, and that many have compared to 2012 Nirbhaya gang rape in Delhi, which called for stricter law. A large part of that criticism has been about the treatment of the young woman's traumatized family, allegedly locked up in their homes while the victim was hastily cremated. Shocked by the alleged gang rape and murder of 20-year-old woman and her forcible cremation by the police, subsequently, the Lucknow bench of Allahabad High Court on 1st October has summoned top government officials to the court. A division bench of Justice Ranjan Roy and Justice Jaspreet Singh had ordered the Uttar Pradesh Additional Chief Secretary, State Police Chief and an Additional Director General of Police to appear before it to explain the incident. The bench also ordered Hathras District Magistrate and Superintendent of Police to appear to brief the court, including the ongoing probe into it. The incident, which took place after the death of the victim on 29 September this year, leading up to her cremation, as alleged, have shocked our conscience, and therefore we are taking so moto cognizance of the same, the court has said in its order. The Supreme Court has adjourned the habeas corpus plea filed for the release of Kerala journalist Siddique Kappan, who was arrested by the Uttar Pradesh police while he was proceeding to cover the Hathras case of rape and murder of a 19-year-old Dalit woman.
While adjourning the plea filed for the release of Kerala journalist Siddique Kappan for 4 weeks, The bench headed by Chief Justice of India S.A. Bobde informed senior advocate Kapil Sibal, appearing on behalf of the petitioner, to approach the Allahabad High Court. Sibal submitted to the court that the instant plea had been filed when it was a habeas corpus. However, subsequently, an FIR had been registered and the Unlawful Activity Prevention Act was then invoked. He further informed the court that no court in the state of Uttar Pradesh would grant bail to the petitioner. "Let us approach you under Article 32, requested Sibal. The CGI, however, was not inclined to issue notice and directed Sibal to approach the Allahabad High Court while adjourning the matter for 4 weeks. Sibal stated that the petitioner would continue to remain in jail, and to this, the CGI responded, "You approached the High Court, we are here only." Terming the arrest illegal and unconstitutional, the Kerala Union of Working Journalists has filed the petition seeking Kappan's immediate production before the SC and release from illegal detention. The petition contends that the arrest was made in violation of the mandatory guidelines laid down in the decision D.K. Basu versus State of West Bengal and was made with the sole intention of obstructing the discharge of the duty by a journalist. The family member of the colleagues had not been informed of the arrest of Kappan, who also happens to be General Secretary of the KUWJ, the plea said. He is contributor to online Malayalam news portal Azimukham. As per report, Kappan, along with 3 other journalists, Atikur Rahman, Masood Ahmed and Alam, were detained by the UP police at Hathras Toll Plaza on 5th of October, alleging links to the Popular Front of India or PFI, an outfit the UP government wants banned. Their mobile phones, a laptop and some literature which could have an impact on peace and law and order in the state have been seized, said the police in this statement. On 11 September, a 20-year-old Dalit woman was abducted and then allegedly gang raped by 4 upper caste men who then subjected her to brutal torture by breaking her bones and cutting off her tongue. She passed away on Tuesday, the 29th September. Her family complained that she was cremated by police officials in the middle of the night without their consent. As public outrage was mounting over the police action, widely perceived as an act to erase evidence, the UP police issued public statement denying rape, contradicting the dying declaration given by the girl. Upper caste groups have started a counter movement claiming the innocence of the accused person. On Monday, the UP police registered an FIR against unknown persons for charges of sedition, promoting social disharmony, etc., alleging that the protests over Hathras incident were part of an international conspiracy to malign the state. Bureau Report.
And senior advocate Harish Salve, while appearing for Arnab Goswami, journalist and editor-in-chief of Republic Media Network, in relation with challenging the breach of privilege motion against him by Maharashtra Assembly and Legislative Council, said the Maharashtra Legislative Assembly and the Speaker could not be served in the plea. A bench of Chief Justice S.A. Bobde and Justice A.S. Bopana and V. Ramasubramaniam was informed that the office report suggested that appearance had not been entered. In this context, the court asked Salve to file an affidavit stipulating service. Senior advocate Abhishek Manu Singhvi appeared for the state of Maharashtra and informed the court that he had no role to play in the present petition. CJI Bobde then proceeded to state that in the assembly, when one member alleges statement against another member, then the speaker takes note of it and forwards it to the privileges committee. My late father and Nani Palkhiwala was served such a notice by the Maharashtra Assembly, he added, and the case is now listed for 2 weeks. On the last date of hearing, senior advocate Harish Salve had argued that the privileges of an assembly could not be used against someone outside of the House. He added that the breach of privilege and could only lie if there was any hindrance, obstruction, interference by a person and interfered with performance of duties or working of the House. Actually, the breach of privilege motion was moved against Goswami by Shiv Sena MLA Pradeep Sarnaik, accusing Goswami of using derogatory language against Chief Minister Uddhav Thackeray and NCP President Sharad Pawar in relation to inaction by the state government in the unfortunate death of actor Sushant Singh Rajput. Party legislator Manisha Kayande moved a similar motion in the Legislative Council. Following this, a 60-page notice was sent to Arnab Goswami stipulating that he has breached the privileges of Legislative Assembly of Maharashtra. A similar motion has been moved against actress Kangana Ranaut for her alleged derogatory remark against Maharashtra, comparing the state to Pakistan-occupied Kashmir. The Supreme Court on Monday issued notice in a plea seeking equal protection of laws to the transgender community from sexual crimes in the context of the Indian Penal Code. A bench of Justice S.A. Bobde, Justices A.S. Bopana and V. Ramasubramaniam asked senior advocate Vikas Singh, appearing for the petitioner, as to how many times the court had legislated upon similar cases.
This is a good petition, the CJI S.A. Bobde observed, when the plea seeking equal protection of law to the transgender community from sexual crimes came up for hearing before the three-judge bench of the top court. The plea states that there is no provision or section in the IPC which may protect the third gender from sexual assault by males, females, and from the other transgender and anti-discrimination laws are needed to safeguard the transgender community, stating that clauses 1, 2 and 4 of the subsection 1 of section 354A of IPC exclude victims of sexual harassment who are transgender persons. Plea states that the provision is challenged in the plea as being ultra-vires, Article 14, 15 and 21 of the Constitution of India. In light of this, the petitioner has filed the petition to make appropriate modification or interpretation of section of IPC dealing with sexual assault to include transsexuals, eunuchs in its definitions. The petition states that the Indian laws are for men and women, and therefore, considering transgender neither men nor women, they generally could not get justice from the authority due to lack of law. The third gender, they are being deprived of many of the rights and privileges which other persons enjoy as a citizen of this country. The state cannot discriminate them on the ground of gender, violating Articles 14 to 16 and 21 of the Constitution of India. Further, pointing to Article 21, the plea states that the greatest and the most inclusive constitutional provision in Article 21 states that no person shall be deprived of life or personal liberty except according to procedure established by law commonly understood as right to life, includes right to live with dignity. In this context, it adds that due to said sexual assault, hate crime, transgender could not live their lives with respect and dignity. Further, the petitioner adds that statistics have documented that incident of sexual violence against transgender indicate shockingly high level of sexual abuse and assault, where 1 in 2 transgender individuals are sexually abused or assaulted at some point in their lives. Some of them have been sexually abused and assaulted while in jail and custody of the police. Furthermore, the plea stipulated that as India is a signatory to the Universal Declaration of Human Rights, the right to relating to life, liberty, equality and dignity of the individual guaranteed by the Constitution and embodied in the international conventions and enforceable by the courts of India. In this context, the petitioner has sought a direction to the centre to make appropriate writ, order or direction in the nature of mandamus directing the respondent to make appropriate modification, interpretations of section, provision of IPC dealing with sexual assault to include transgender, transsexual, kinners and eunuchs in the definition. Additionally, the plea prays for directions to make gender-neutral sexual harassment mechanism, pass an anti-discrimination bill that penalize discrimination and harassment on the basis of gender, as well as to frame guidelines to protect the fundamental rights of third gender by giving them equal protection before law till such time as the legislature to safeguard by protecting third gender from sexual assault. Bureau Report.
And the Mumbai High Court, while hearing a petition, said that doctors should regard their service to be rendered as a call for joining national duty. refusing interim relief in a plea against alleged arbitrary placement of doctors at various government hospitals for 1 year mandatory public service. The Bombay High Court remarked, in these difficult times of the corona pandemic, people in the rural areas needs adequate medical treatment, and we are of the prima facie opinion that doctors like the petitioners and the others should regard the call for service to be rendered as a call for joining national duty, so as to reach out to the distressed and the needy. The bench of Chief Justice of Bombay High Court, Dipankar Datta and Justice G.S. Kulkarni, however, observed that the matter deserves expeditious consideration and ordered the respondent to file a counter within 10 days. The court was hearing a writ petition filed by 3 doctors in representative capacity on behalf of 92 other doctors, stating that list of placements for mandatory public service was arbitrarily prepared, without bearing in mind a binding decision of a coordinate bench of the High Court, as well as ignoring the merits of the respective candidates. They had sought setting aside of the list as well as for direction of the state to display all the available seats and to allow the candidates to file up their preferences, which would lead to their selection in accordance with merit as was followed till the academic year 2019-2020. The court, however, noted that the interim prayer made in the writ petition were also subsequently the same, except that instead of setting aside of the list, stay of operation therefore had been prayed for. In these circumstances, the court observed that an interim relief subsequently in the nature of the final relief may be granted only if a very strong prima facie case is made out of the petitioner favour. And the Bombay High Court, while allowing lawyers in Mumbai metropolitan region and registered clerk to travel in local trains, observed that time has come for the state government to identify employees of other sectors too who could gradually be allowed to avail suburban train services. A division bench of Chief Justice Dipankar Datta and Justice G.S. Kulkarni were hearing a batch of PILs and a writ petition seeking inclusion of lawyers in the list of essential services that are allowed to travel in the local trains. Previously, in an order dated September 15, the bench had allowed lawyers attending the High Court to travel in local trains on an experimental basis. On Friday hearing, the court had allowed lawyers appearing before other courts across the Mumbai metropolitan region to apply before the registrar specially designated for the purpose of the senior most magistrate at the concerned station for issuance of certificates permitting travel of lawyers by local train for attending remand proceeding, whereas registered clerks are required to attend the principal seat for the purpose of physically feeling of matters, were asked to apply through an email to designate the registrar of the High Court seeking a day pass. Advocate General of Maharashtra A.A. Kumbhakoni had vehemently argued that people were failing to follow the basic preventive measures against the virus while travelling in locals. He submitted a letter by the Divisional Railway Manager Officer, Commercial Department, Mumbai Central Western Railway, listing out 14 categories of essential services staff who have been permitted to travel in EMU trains on demand from the state government. Employees of the judiciary and dhabawalas are also included in the said list. Apart from suburban train services, BEST has been operating a sizable number of buses in the Mumbai as well as beyond Mumbai limits. A.G. Kumbhakoni informed the bench. He also submitted that the number of buses presently plying would be doubled in the MMR. Well, that's all for the Courts Roundup today. Thank you for tuning in. Keep watching.
India Legal presents Courts Roundup.